Your Honor, today is the date and time set for a probable cause conference. At this time, we would like to schedule this matter for a preliminary examination.
And all discovery is complete.
Yes, Your Honor.
People have their witnesses available the 3rd.
We will do our best.
Preliminary examination in person, September 3rd, 2024, 9 a.m. before Judge Perry.
Your Honor, may I briefly address bond?
Okay.
Thank you. Your Honor, Mr. Blair's bond is currently $10,000. He cannot post that. I'm asking Your Honor to consider lowering his bond to a personal bond, but if not a personal bond, at least a 10% provision. Prior to this, Mr. Blair had job interviews at both Applebee's and Five Guys. He believes that those are still going to be available to him. He has no prior felonies. And Your Honor, and for what it's worth, I have been contacted numerous times by the complaining witness in this matter. I have not reached out to them. And I'm constantly being told that these allegations are lies. So I'd like Your Honor to take that into consideration for what it's worth.
Response from the people.
I do want to correct, the defendant does have a prior felony. He has a CCW conviction out of Georgia from 1996, as well as a reckless conduct and a trespass all out of Georgia. As far as this particular case, the defendant was driving 120 miles on the highway.
Excuse me. Look this way. Thank you. Go ahead.
He was hitting barriers, assaulting the victim. The victim called 911 and was screaming out the window for help. He pulled into a gas station, got out of the car, and pulled the victim out of the car by the hair and started punching her. Officers arrived to see the defendant physically assault the victim and the victim crawling on the ground to get away from the defendant. The defendant then resisted officers before successfully being placed under arrest. At this point, we did request $500,000 cash or surety for bond. He had said $10,000 cash or surety and getting the time would be appropriate.
Anything else?
Your Honor, just for the information prior to any of the officers' involvements, I guess those are all fabricated from what the complaining witness had put in an email to. So I was just asking Your Honor to take that for what it is.
Motion for bond reduction is denied. Bond will continue. Thank you. Call the case of the people versus Christopher Brooks Miller.
Edward Rubis on behalf of Christopher Brooks Miller, who's approaching.
Oh, we did get Charles. Got it. Okay. Go ahead. Let's go on.
Scott Brooks Miller, Your Honor.
Thank you. What are we doing?
The court should be in receipt of a plea form.
I am.
There's a transfer form as well and a signed waiver. Transfer form, I think, is a financial form.
The MOU.
Yep.
I do see that. Is it going to be a drug court case?
It'll be a veterans court case.
Pardon?
Veterans court.
Okay. And we have to, well, still have to be, I got it. Okay. All right, very good. The court's understanding of a plea agreement is that the defendant would be pleading guilty to attempted use of self-defense spray. That would make it, the attempt would make it a 1-year misdemeanor. Upon his successful guilty plea to that charge, count 1, the 2-year would be dismissed. There is an agreement to veterans court treatment. Is that correct?
That's our understanding.
That's correct. Thank you.
All right, very good. Sir, has he signed any advice or rights form?
Yes, it should be in that stack of paper.
Yeah, it is. All right. Can I have him raise his right hand, please?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got.
I do.
State your name.
Christopher Scott Brooks Miller.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted use of a self-defense spray. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that, sir?
Yes, sir.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
How do you plead?
I do plead. I'm sorry.
No, it's okay. You plead guilty or not guilty to that charge?
Guilty.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes.
Any question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No. No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
If I go say the rosary every day, I'll go to heaven.
Pardon?
If I say the rosary every day, I'll go to heaven. That was Sister Monica.
Was it promised in this case?
Oh, no.
Okay, that was probably promised a long time ago. All right. Anybody promise you anything else, sir?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, sir, I am.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes.
June 11th, 2024, at the location of Waters Road near Parker Road, Lodi Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
Car was going to pass me
Got out of the car.
and it was a double yellow line. I pulled in front of him so he couldn't pass, and I pulled over and he pulled over behind me. And words were going back between us, and he said something that triggered a self-defense mechanism. I'm not in any way capable to get into a fight. So I grabbed my trusty little can of pepper spray that I keep on the visor and try to give him a squirt, but
Okay.
the car for 4.5 years, they don't work very well.
Got it. Okay. And you did not have it. The device that you used, you didn't have any lawful authority to use that, you would agree?
Oh, sir.
All right. Well, I asked that question badly. You would agree that you did not have lawful authority. Is that correct?
Yes.
All right. Counsel?
Defense is satisfied.
Court will accept the defendant's plea of guilty to this charge. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14-4 court. That's where the initial
At the
transfer will occur.
15th district.
No, I think it's what's going to happen is he's got to go to 4,
Okay.
be sentenced, and then the transfer happens.
Thank you, Your Honor.
Sentencing in this matter will be
September 3rd at 9 a.m.
September 3rd, 2024, 9 a.m.
Yeah.
before Judge Fresh Hour. Will continue. And I may have asked you this before, sir. What branch?
Marine Corps, sir.
How many years?
Not quite 5.
Well, I'll say this. Doesn't define the person, this case doesn't define the person that you are. Thank you for your service. I realize because of people like you, I get to do what I get to do every day. So thank you for that. All
Thank
right.
you, sir.
Take care.
All right, Your Honor.
Thank you, Your Honor.
Yes, to my left.
Other side.
Oh, right. Sorry.
And your name, sir? Thank you.
Well, I'll just start. We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A
converted
second case on
on the same, calling from the jail. Allegedly, everything's allegedly.
the
Calling
witness,
from the jail.
right? Okay, he picked up the,
Everything's alleged.
Right.
So that caused a second case and, in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too. Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me. When defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this, you were fighting for him, you were fighting at me a little bit with this thing. And then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, you know, that fight it wasn't quite anything you did. It's just in your, it's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forth, but you understand that, Mr. Abs?
I understand everything.
Okay, then let's let.
Right.
Correct, so,
Just to the courts.
He has discovery on the first one.
on the first case, but not on the
Yes.
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it
Correct.
all, so I wanna make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on with our victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Would the court please explain to my clients certain instances where they can go forward without the victim? Excited under its mental state, it's.
There are exceptions to the hearsay rule.
The victim-
Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Abs. And so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of
that's,
the technicalities would be MCL 768.27C. And as I indicated, that case, people versus only 327, Mishap 319, and the
Yeah.
various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all,
And-
it's
and
all
other.
of that kind of thing.
Do I got a
They-
right to cross-examine my accuser?
You know what? Here's the thing, sir. That, if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying there, that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law. school
Okay,
for
I'll
her.
tell you-
She asked the
We
question.
have told you.
I
I'll
asked
tell
All right,
you-
I'm done. I'm gonna set it for exam.
I'm gonna go to the jail today, so I will,
So
I'll
what's
tell
that?
you.
Preliminary examination in this matter, because the
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse me.
Why so long?
Uh,
That's 3 weeks.
yeah, September 17th, I can do that, but
Why
not
so
the
long?
8th, because that's the judge's calendar, and I'm a deferred professional. There are some
You can ask
parameters,
for
and you
another
are not
speedy day.
being. Oh, that's the new
In-
thing in the jail I'm learning, that I'm being.
And I would anticipate the
Oh.
people's motion, so we'll try to
Speedy
hear
trial
that.
is the new
before the-
buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has,
Judge, can I ask a question? What is about what's going on in the jail, speedy, none of this
You
particular
just
about
said
my
speedy. You
case.
just said you had a right to
Like
speedy
this, I
trial.
didn't say, I asked, why so long? I didn't say nothing
It's
about
not
no
a
speedy
violation
trial.
of speedy
I asked,
trial.
why so long? I didn't say nothing about no speedy trial. Like, Judge Sim, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
okay,
All this
but Mr. Epps,
speedy
hold on,
trial-
slow down. You have two things now which have,
And I
hold
understand
hold on. You asked me a question, but you're operating off of a premise that isn't gonna work. So here's the thing, you had the one case come up. We then had the hearing, there were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay,
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you. for
And
that.
I'm not trying to do that. I'm just trying to explain the process and I've got to, Mr. Epps, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up. Okay, so that's the reason for the stretch out in time.
Okay,
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed presumably, and I don't know, they know this for sure, without the witness, your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
I'll say one more thing, sir. Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We talked,
I'm not able to get a hold to you.
I don't.
but we talked.
That,
Somebody else know.
Oh, he's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
you should be able to contact your attorney.
I'm not able to, sir.
Well, did somebody at the jail make sure that that can happen? Ms. Ford, check into that if you,
All right.
I'm
we
done
are.
here, folks. Bond continue.
Thank you.
Case of the people versus Michael Horn.
Deborah Jordan, on behalf of Michael Horn. This is a happy story.
Oh, you don't want me getting after him?
No.
No, okay, I'm just asking. I'm just trying to be helpful. Your name, sir? Thank you.
He's asking for a preliminary examination.
All right, and I'll discuss.
Calls, he doesn't
What?
belittle me, and he listens, and he calls his probation office, what's it? Tether, I call probation, but Tether agent Josh Bennick, I've spoken with him. He cooperates, wants us to know.
Wow, it's funny how that works out better when you do that. I don't know. And it's interesting when you kind of do that, he's out. The other guy, I don't know. Something.
He is asking though for one thing, while I remember.
Oh, now he wants me to see.
Yeah.
I knew it. And anyway, go ahead.
But he really, everything I said though was accurate. He would like bond permission. I call it tether to go look for work from 6 a.m.
Okay, hold on. Let me first do this.
No, excuse me, 8 a.m. to 6 p.m. Right.
Hang on. Let me first deal
Sorry.
with setting the exam.
Okay, sorry.
Okay. So would the people have their witnesses available the 3rd?
We'll do our best.
I know I have a major exam in Rochester Hills.
What about the 10th?
The 3rd is fine. We'll do our best.
I can't,
So would the 10th work for you?
We'll do our best.
just a minute.
So
Is it
I'm taking
possible-
that as a yes.
As far as I know.
Oh,
All right.
Is it possible to put it on the same day as the other case?
Get to choose.
Is that too much?
Okay, I'll put it there, but you may be before another judge. Because you don't get to choose that either. So, I mean, it's just gonna be, it will likely, okay, look. Let's just do this. Before I give a date, what is your other request with the tether?
Oh, from 8 a.m. to 6 p.m. that he can look for work.
Who is that? Blanche? Is that Blanche? Oh, that was you? It was Blanche? Yeah, it sounded like a Blanche sneeze because she interrupted the court like 8 times the other day. Okay. Do the people have a response on the request to go look for work?
I will say I'm a bit confused why he needs to get Heather to go look for work for that large of a time span, if he had an interview set up or if he had employment already, I would be more inclined. But he's out on a PR with home confinement and we requested 250,000 cash or surety in this case. because it is a firearm case. He has a prior CCW from 2023. There's a CCW, PD, and A and B, and an L all up here. It's about the defendant texting threatening messages to his ex-girlfriend, showing up in a car, pulling up alongside her, punching her multiple times. And this is after threats. He then grabs a gun, points it at both the victims before leaving. I'm
Okay, so here's what I'm gonna do.
May I say, just respond before I do by a little bit? Okay, he indicated he was not convicted on any gun case, but more importantly, people do murder and get out and they.
Not here, they don't.
Well,
I don't know where you've
no,
been.
this is my
But,
client.
you know,
He get
okay,
out,
look,
get job.
here's the thing.
He doesn't.
Here's the thing. I'm gonna give you your exam date. I'm not changing anything regarding bond.
Okay,
Okay? I'm just gonna leave everything where it is currently.
okay.
Okay? So what date did you need, counsel?
Thank you. September 17th.
Preliminary examination in person, September 17th, 2024, 9 a.m. before Judge Balvo. Here it is. Court does call the case People versus Robert Half. I think this is your person.
Excuse me, I want to bring your sweet little faggot rag like down here so I can beat it. Get out of fucking fuck.
Yeah. All right.
It's
Here, we don't need him to give his name.
Oh, yeah, like, rag.
Okay, so
Lord Brown,
say something.
Lord Brown, public defender, a fighter for his clients.
All right, so what are we doing in this case?
Does the court have an updated report? This is a competency report.
I do not have an update. Well, I do have something from August 9th.
I think that's the most updated, Your Honor. That's the most updated.
And indicating that he still remains incompetent to stand trial.
Your Honor, I'm not surprised at that finding. And I would ask that we set a new
Review date. I can do that. So I'll set a competency review date for November 21st, 2024 at 9 a.m.
Thank you.
Bond will continue. Thank you, Mr. Hatt.